that I've been doing on this channel. But nevertheless, we're going to keep it professional. The judge in the YSL court cases this kangaroo court has been going on for long enough. And this judge better hope that he doesn't lose his law license by the time that this trial is over. What he ended up doing is like a backroom deal with the DA in his chambers, but he did not include the lawyer of Young Thug. So that's enough of me talking. I'm gonna set the stage. They want the judge thrown off the case. They want them thrown off the case. Well, but that's enough of me rambling. Let's dive into it.
Lawyers for Young Thug are calling for a mistrial after a key witness in the case refused to testify against the rapper. Now, Kenneth Lil Woody Copeland is being held in contempt of court as the trial resumes this morning in Atlanta. ABC News legal contributor Brian Buckmeyer is here with more on that. Brian, Copeland pleaded the fifth despite being granted state immunity for anything he testified to, and he was expected to testify against Young Thug. So what does this mean for the trial now?
That's the big question, Diane. Copeland is supposed to be the major witness for the prosecution, connecting Young Thug or Mr. Williams to this case. He's supposed to be the one that's going to tell the jury that Young Thug rented out a vehicle for him to do a drive-by and connecting him to this entire RICO case. It's supposed to be their biggest witness against Young Thug, but without him testifying or pleading the fifth, and we expect him to do the same this morning, the question is what happens to their case against him?
Now, the defense called for a mistrial after Copeland pleaded the fifth in front of the jury. What's the strategy there?
Yeah, so no attorney, whether you're a prosecutor or defense attorney, can put on a witness in front of the jury, knowing or suspecting that that witness is going to plead the fifth. It's because there's an innate sense of bias that harms the defendant or even the prosecution at times. Think of it this way. Copeland pleads the fifth. The prosecution throughout this case has said that he was part of Young Thug's criminal mastermind to do this drive-by against one of the victims who was actually murdered in connection to this case. Now Copeland pleads the fifth. What's the jury to believe? And there's no correction that a judge can cure in saying, well, don't look into it that he pled the fifth. Just keep moving along.
Now, this trial has been going on, Brian, since January 2023. So what are you watching for next, and how much longer do you expect it to go on for?
It really depends on Copeland. If he takes the stand again and pleads the fifth, and I slightly disagree with the prosecutor and the judge here, because let's be clear, he's got immunity from state prosecution. That doesn't mean that the feds can't be watching his testimony, potentially have an investigation based on that. And I think that's part of his fear, along with just the fear of being out in the streets and being a snitch if you're involved in gang activity. But if he doesn't testify against Young Thug in a way that the prosecution has said that he would, the question is, are they going to continue with the case against Young Thug? Are they going to have a trial or dismissal because they can't prove a serious element against him in this drive-by shooting that led to a murder? So I'm watching to see this morning as to whether or not Copeland pleads the fifth or he testifies the way the prosecution wants him to.
All right, Brian Buckmeyer, thank you.
All right, so now that we played that, let's dive into what we really want to talk about. Brian Steele, the lawyer for Young Thug, was and is having a conflict with the judges over the trial. This is absolutely kangaroo court. That's enough of me talking. Let's dive into the video.
The court to look into the appropriateness. Mr. Copeland, to my observations around your courtroom, outside your courtroom on breaks, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair, and I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness? He's not in custody, and bring a witness. I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor, so if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs? So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him or the prosecutors think.
I don't have any thoughts. So please don't put that in. Please don't put that in the ether. Okay, but that's what you just said, sir.
The ether is clear. The court wouldn't do it. I wouldn't do it either. So why is it happening?
I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence.
Mr. Steele, we're not gonna get into that right now.
Well,
okay?
my point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this.
I'm not going to be interrupted.
Mr. Steele, hold on. No, but you're Mr. Steele? Mr. Steele?
Yes, sir. What?
Okay.
I want to finish. I'm making a record for the court to understand.
Well, Mr. Steele.
I've never been interrupted in a court except for this one. You allow.
Well, you know, but the challenge is in this point in time is that some of the things that you have said at certain points in time are not appropriate.
It's not true.
Okay, well that's the court's. The
court is wrong.
Well, you know, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time. But finish up so you can go ahead and make your record.
I'm not interrupting anyone about a prosecutor or anyone. This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so. Well, we don't know that. We don't know whether or not they're true.
Going on. Every time Mr. Copeland comes in the courtroom or out of the courtroom, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why?
Okay.
Why do I have to bring up? You should be bringing up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial.
If you make at least 150 grand a year and you're still embarrassed to take your shirt off at the pool, I'll get you.
So I'm moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional remember what I told you about your, and she's going to take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record. Okay?
I understand the one party talking. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility and let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. So but
Ms. Love has intentionally lied to the court numerous cases. You do nothing.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. It is not a good idea to state that your brethren across the bar are lying, okay? At any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't have any proof. If you have proof of it, then if you have proof, there's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for an investigation to occur. But please stop, both of you. I told both of you earlier, stop making these ad hominem attacks toward one another. Okay?
Everyone gets attacked. You say nothing.
Well, okay, but I've said something. You're going back to stuff that's happened in the past. So while I'm trying to deal with things that are current. So I told you all most recently, as of about a week or so ago, to stop all this. Remember I told you the world's watching you? They are. So please don't from this point on, do not accuse each other of anything. If you want to go ahead and do it, there's a proper way to do it, but don't bring it up in front of me. Okay?
I'm just making a point that this has been going on and it's abusive. That is my point.
That's your assertion, sir, as a lawyer, okay? And maybe your frustration with everything. Like I told you, this trial's gone on a long time. There's a lot of wear and tear, but everybody's got to rise above and be a professional advocate. That's what the system demands of you.
I'm not worn or torn. I am here to tell the court that from a objective, casual observer could see what's going on here is inappropriate.
Okay. At the end of the day, I understand your concern that you have now shared with the court. Okay. All right. State, do you want to respond?
Your Honor, I just ask that the court strike the portions of Mr. Steele's, whatever that was, to the court regarding personal and ad hominem attacks on members of the state's team. Ms. Hilton will address the merits of the initial argument that Mr. Steele made. But as to personal attacks on members of the state's team, we'd ask that assertions that specific people have lied, that is disrespectful, that is unprofessional, and not one time has any such statement been made by any member of this team about anyone else.
I think, Ms. Love, in the past, you've made some statements.
I have never said anyone lied.
Yeah, you made some statements about Mr. Steele and about, well, just let me finish. I'm not done. All right. And about several others of your colleagues. I mean, and it may have been the heat of discussion and everything else. Like I said earlier, there's enough blame to go around for everybody. All right. So, but can we kind of stop that and draw things kind of forward? I've had 2 or 3 conversations with everyone about their obligations as professional advocates under the rules. Okay.
Searching for music for your next video? Then you need to check out our...
Okay, that's how that trial went. But what if I told you that things heated up a lot more? Because guess what? Brian Steele in the next trial was arrested. He was arrested. But let's go.
We're continuing our coverage on the drama-filled YSL trial. On Monday, Young Thug's lawyer Brian Steele was held in contempt and arrested in the courtroom. You're taking a look at some footage there of that entire scenario. Today, we're learning that Steele has been granted bond pending his appeal of the contempt order. And for more on that and all the fireworks in court this week, we're joined by legal affairs journalist Megan Kenneth. Megan, always good to see you. You've been on top of the story from the beginning, and now it seems to be ramping up again. So what do we know today?
Yes, today there was a recusal motion brought against the judge who actually ordered Steele held in contempt of court. It wasn't specifically ordered over the contempt finding, but it was over this private meeting that led to the contempt finding. Brian Steele, Young Thug's lawyer, was held in contempt of court because he wouldn't tell the judge who told him about this meeting that the judge had Monday morning with the key witness and prosecutors, and the defense wasn't notified about it. So today, there was a 15-page recusal motion filed against the judge regarding this meeting. It had a few different reasons stated in there, but the judge promptly rejected it. But then the big news came this afternoon when the Georgia Supreme Court actually stepped in and gave Brian Steele bond pending his appeal of this contempt order. So he is not going to have to go report to jail Friday at 7 p.m. I think that was expected from most everyone regarding this appeal, but it's official now that he does not have to report to jail Friday at 7 p.m. And this appeal of the contempt order will proceed. And I think a lot of people are expecting that he has a pretty good chance, but this was a pretty quick rebuke against this move against Steele by the Georgia Supreme Court.
Megan, I'm sure that this is causing so much concern when it comes to this trial. We've been hearing so much about even people, being against the prosecution and what they've brought forth here. And now we have this latest drama in the courtroom, if you will, over Young Thug's lawyers. I think the question now is a judge single-handedly allowed to refuse any recusal requests? And even if people are accusing this judge, so to speak, of being impartial in this trial?
It depends on the jurisdiction in the court. In the federal courts that I cover in Los Angeles, actually, the Central District of California was an outlier for a long time and allowed judges to consider their own recusal motions. But they changed that in the last couple of years, and now the motions go to another judge. I'm not quite sure what the exact procedure is in Georgia State Court, but Doug Weinstein, who brought the recusal motion, was really making the case that Judge Glanville needed to pass this on to another judge, and even said, Judge, don't you want to get out from under the cloud that's hanging over this case right now? And Judge Glanville just said, he read the motion and he wasn't granting it, that his decision was made. So these are the kind of things that happen in these cases that are ongoing, these trials that are ongoing, and there really is no recourse for them beyond an appeal at the end of the case. If there's a judgment and sentence rendered in this case, then they can go to the Court of Appeals and raise all these issues that happened in trial. But what's so unusual here is this is such a long trial. We're looking at least through the end of the year, probably well into next year, we're going to be having this case.
Such a long trial, Megan. I'm glad that you said it, because it really does feel that for months we've already been talking about this. And we were talking a little bit before I brought you on. It kind of seemed to drop off a bit and now ramping up all over again with the latest drama in the courtroom. So let's get back to what happened yesterday with Kayla Bumpus. She withdrew from the case and later posted it online, calling it a circus.
Okay, I'm going to take a quick break because I also want to show you how the process of Brian Steele being arrested. So give me a minute. Let me pull that video up as well. I apologize that I didn't have it ready, but I definitely want to show you what happened, because it's just not a good situation where this circus of a court arrested him. So let's go back into the case itself, and I want to show you when the judge had Brian Steele arrested. So let's go there.
You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. It doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5.
Okay, so I definitely want to play that before we get back into the video that we were playing, so you can get a full understanding why people were upset. I don't normally pause the videos, but I had to add that video in so you can understand what people are upset and what, the feedback from Ms. Kenneth.
Pointing to the ex parte conversations, have you heard any more of that?
No, I haven't. And, we haven't heard anything like that. And those are the kind of things that would be brought in written motions and, made a little bit more formally. But I think the statement about this being a circus, there's so much extraneous stuff and people get so excited about, the drama that happens when the jury's gone. But in my experience covering trials, that stuff is such a distraction and such a noise that, it just becomes contrary, and it clouds the actual testimony that's going on when it's so important to actually look at the actual case and the testimony and how prosecutors are trying to bring this gang conspiracy case over all these different acts and things that happened over the last 10 years. So the drama that happens between the attorneys, I think especially right now, I can see why it got everyone's attention, because this is such an unusual move by Judge Glanville, not only the contempt order, but the meeting that he had. And the meeting is what really gets into the heart of the case, because Kenneth Copeland is such a crucial witness. And there was a moment this afternoon that I thought was kind of alarming, because Max Shard, who's an attorney for Shannon Stillwell, has raised the issue of, and so have the others, that they need to get the statements that Kenneth Copeland made during this private meeting, because he's such a crucial witness and a cross-examination is coming up. And if he made statements that are contrary to things that he said before, because he was originally charged in the murder of Donovan Thomas, which is a big part of this case. It's a big question of this case is who killed Donovan Thomas. And the defense contends that it was still Kenneth Copeland. But a couple of the guys who were on trial, including Shannon Stillwell, are actually charged with Thomas's murder. So it's obviously in Shard's interest to get any kind of statements that Kenneth Copeland made during this meeting on Monday morning about Donovan Thomas's murder. But Judge Glanville, who did not even notify the attorneys about this ex parte meeting, which if he's going to have ex parte, which is the one-on-one discussion, one party only discussion with attorneys, he needs to notify the other side, and he didn't do that. But he told Max Shard today that he's still combing through the transcript and seeing if there are any releasable statements regarding Kenneth Copeland. So I think that's kind of an alarming testament of what's going on and how these decisions are really affecting the case and the testimony, because we have a cross-examination coming up that they're trying to prepare for. And it sounds like they don't have all the material yet, but Glanville's not sure what's releasable or not yet. But.
With Norwegian, wake up to a new city nearly every day.
Anyway,
there's just so many questions still left with this entire trial and this case. And like you said, there's so many points that we have to tackle on to try to make it coherent and cohesive for maybe someone that's not even familiar with this particular case. So Megan, I want to leave you with the last word here, because you mentioned a good point, which is this whole term of it being a circus now and kind of all over the place. It's gotten really the attention of so many people, but there's important things that we should be focusing on, specifically when it comes to testimony that's actually prevalent in this trial. So what are you looking forward to in the weeks ahead, and maybe something that we've lost sight of along the way?
I think in the weeks ahead, we're going to be hearing more about Donovan Thomas's murder. And there's actually a rapper who's from Atlanta and pretty well known. He goes by Rich Homie Quan. It's his performer name. He's supposed to be taking the stand because he was friends with Donovan Thomas and part of this whole group. So there's a lot more testimony that's going to come out here. But I mean, as Doug Weinstein said when he was arguing his recusal motion, there's such a cloud hanging over the case right now with all the attention that this contempt order and Judge Glanville's actions are getting. So while we have the Steele not going to jail on Friday, we still have the issue of this contempt order under appeal. So it'll be interesting to see how fast the court acts there, because if they end up throwing out that contempt order, it'll be interesting to see if there's any kind of changes in Glanville's behavior or if that kind of takes him down a couple notches.
All right, just posting up some more footage from earlier this week, because again, Young Thug's lawyer, Brian Steele, you see him there being held in contempt of court. He even saying that he was going to share a jail cell with Young Thug, if I'm correct, with this entire, and that's what's really taken over social media at the moment. But I do appreciate Megan Cuniff, legal affairs journalist, for coming on and again, kind of reeling it back in, putting into focus what really needs to be paid attention to when it comes to this trial. And we still have such a long way to go. So Megan, I look forward to connecting with you as we continue to process all of these new developments.
Absolutely. Thank you so much.
Thank you.
All right. So I just wanted to bring a lot of attention to what actually happened in this case. Your lawyer gets arrested because the judge is doing backdoor deals with the state attorneys. And the witness that was supposed to testify, that's one of the anchor witnesses to this case, to gain a prosecution against Young Thug, he pleaded the fifth. So now the state is all conflicted what to do next. So it's a lot going on with this case. Sorry for that I had to pause it and throw that information in. But nevertheless, please like, comment, subscribe, as we're coming to you with more videos in the future. And once again, we will see you in the next video. Hit the notification bell. You can support the channel. Cash App is in the scroll bar.